Thank you very much for coming on a miserable, slippery night. Can you all hear me all right? Yes? Great. I'd like to start by thanking Augustine College and Todd Anderson for the invitation to come. This is a fantastic venue. It's not often I get a chance to lecture in church. I also want to thank especially Barry Bussey. It may have been Edmund Burke, and it may have been John Stuart Mill, or it may have been one of a number of other people who first said that all that is necessary for evil to triumph is for good men to do nothing. And I just want you to know that the person we just heard from, in case you don't know him, Barry Bussey, is one of those good men who are doing everything. Barry is a man of conviction, of insight, and energy. He's a lawyer, an author, a scholar, a freedom fighter, and a gentleman. And he sees, like many of us do, that things are not right in this country. And he is putting all of his energies into the enterprise of trying to tell Canadians what is going on, what the story is, to wake people up, and to try to get us on the right side of these times. So, Barry, thank you both for the invitation and for all you do for this country. Thank you. Now, Barry referred to Dief the Chief's words. He made these comments in the context of the Bill of Rights, the statute that was being passed around about 1960. And of course, I agree with the sentiment entirely. But the reality is, today, I'm not sure that what he says is true. Being Canadian should mean all these things. But it's not so clear that today it actually does. And I want to talk to you today about a mistake. And the mistake is one of the reasons why these words today maybe are not so true. Kings once ruled England with absolute power. Their word was the law. Centuries of struggle and reform overcame their tyranny. We adopted this thing called the rule of law. We established checks and balances, limits and restraints, individual rights. For a while, it worked. The law in Canada, as in other common law countries, provided a system of justice as good as anything that civilization had ever produced. But now, it's not working. The rule of law, which is after all just an idea, the rule of law is fading. Because when it suits them, our institutions are placing it aside. Using an idea to hold power in check works only for as long as the powerful believe in the idea. And now they do not. Our mistake We made it a long time ago, but we have been repeating it ever since. Our mistake over these centuries of reform was that we did not go far enough. We did not take power away from our institutions to rule over us. Today, as in the days of kings, the law is based upon the authority of those who govern and not upon the consent of the governed. I remember a moment in the playground. Must have been grade 5 or 6, would have been 10 or 11. We were in the schoolyard, it was recess, we were playing something, I forget what it was, might have been soccer, maybe dodgeball, don't remember. I don't remember the exact dispute that arose. All I remember is the moment in my head. Something was going on, like it often did, wherein the team with the powerful kids were screwing with the rules to make sure that they won. Happened all the time. They were trying to stack the deck. Everybody knew it. All the kids knew it. They knew it was going on. But social status is more important than sport. And I remember this moment because I asked myself a question. And the question was this: when does this stop? When do we grow out of this and become adults who are straightforward, who stop trying to game the system? When will this end? And the answer I came to learn, of course, is never. This isn't just children. This is human beings. In fact, the adults get better at it and get better at hiding it. And that reminded me of this old, I'll go back to that in a minute. This old Lord Acton truism. He said, and I'm sure you've heard of this, he said, power corrupts. And absolute power corrupts absolutely. And the project that we've been on these past few centuries, trying to overcome the king, has been to try to ensure that nobody who rules over us has absolute power. And I think that project has been successful. Even today, there is no one person with absolute power. But here's the thing. The focus on the second part of that truism is a problem. Because once you're satisfied that no one has absolute power, you forget the first part, which says power corrupts. If you want to take that part seriously, here's the lesson. No one should have power. Question: how are you going to have a governance system in which no one has power? Not an easy question, but I hope we'll try to get to some kind of an answer by the end. The law is power. The law is violence. When I have law students come in for their first year of law school, and many of these students think, of course, that they're going to learn the law. It makes sense, right? But what they think is, not all of them, but some of them think that the law is a bunch of rules. You learn the rules, and you're a lawyer. But that's not what the law is, or how it works. So on their first day, I read my students a poem. It's a very short verse by a man named R.D. Laing, who was a Scottish psychiatrist and philosopher who died in 1989. Now, Laing in this poem is writing about interpersonal relationships and interactions. But he might just as well have been talking about the law. The poem goes like this. They are playing a game. They are playing at not playing a game. If I show them I see they are, I will break the rules, and they will punish me. I must play their game of not seeing I see the game. The law is a game. Let me give you an example. I could have picked one of 1,000 examples, but this one is simple, and it's one that you know. It's one that you know already. Here's the Charter of Rights. Here's the right of freedom of expression in the Charter of Rights. Section 2B. Everyone has the following fundamental freedoms. Freedom of expression. This is the free speech provision. What can we tell from these 9 words? That there's no free speech. That is exactly right. You can tell from the statement that you have freedom of speech that you do not. Now, why is that? Well, let's try it. Imagine you're on the sidewalk, and someone comes up to you and says, I have a knife in my pocket. Give me your wallet, or I'll stab you. That's speech. It's also a crime. It's an assault. It's a threat of imminent violence. But how can it be a crime? Free speech. The Charter guarantees free speech. And all the guy did was come up to you and speak. We've seen no knife. There might not be one. There's been no stabbing. There's been no theft. Nothing's happened except the speech. And he will be charged with a criminal offense if the police catch him. How can this be? Well, because the limit, the line in the right, in the Constitution, isn't that. The line is one to be established by the court. Now, nobody I know, including myself, would argue that you should have the right to threaten people with violence. So I'm not objecting to the content of this. I don't think free speech should include assault. But the point is that you can't tell by looking at that. Everyone knows this. Everybody knows that free speech is not absolute, and that some speech is not protected. But it's not just that. It's that the content of the right in the Charter is arbitrary. We pretend that judges give meaning to the words in the Constitution in a manner that is magic. You know, it's bound by precedent, by logic, by principles. And you read the judgments, and sometimes it seems that way, and sometimes it doesn't. But those restraints do not compel the answer. And that answer can change every single time. And as our judges become increasingly sympathetic to the idea of collective good and group rights, free speech becomes less an individual right, as it looks to be in the text, and more of a privilege to speak if, and only if, what you say is consistent with the public good. Ladies and gentlemen, this is not the rule of law. That is not what the rule of law means. It's easy to agree that people shouldn't be allowed to threaten violence. But of course, that's not where the line is being drawn in this country about free speech. You can't discriminate in your public statements. Comedians may not tell jokes that are intended to offend someone on a protected ground. You must speak the pronouns that people demand of you. Doctors are not allowed by their colleges to express medical opinions at odds with government policies. The federal government is curating online content and preparing to censor misinformation, which of course means information that they don't like. This is happening in a country with a constitutional guarantee of free speech, which means that's not worth the paper that it's written on. If the Charter was honest, it would say this: everyone has the fundamental freedoms that courts decide from time to time that they ought to have. Okay? This is not playing the game. This is saying things as they actually are. And the thing is, everybody knows this. This isn't news to you. But people, even though they know it, yet they still play the game of not seeing that they see it. They still harbor the conviction that the Charter means something. If I had $1 for every time someone in the past 3 years has said something like, this is during COVID, something like, but they can't do that. It's in the Charter. So what? That's not the way it works. All the Charter does is take the final call on certain questions from the legislature and give it to the courts. It's only a question of who gets to decide. Okay, but I don't want to give you the wrong impression. The point here is not that power resides in the court. That's not the point, not the point at all. The problem, the original problem, was the king. The king had all the power. His word was the law. That's no good, that won't do. So what did we do? We took power from the king and gave it where? To the legislature. Why is that better? Well, the legislature's elected. That's much better. It sounds better. Oh, that's section 1. This is the Civil Rights Act, 1688, following the Glorious Revolution. This is a provision that reflects the taking of power from the king and giving it to the legislature. Power to the people. Problem is that legislatures can be tyrants too. Legislative supremacy became the foundation of British constitutional democracy. So from the king to the legislature. Legislatures, though, could eviscerate, if they wished, individual rights found in the common law. And sometimes they did. So the Americans had an idea. They said, well, how about we place limits? We'll get rid of the king, first of all, but we'll also place limits on what legislatures can do. We'll create a Bill of Rights. Okay, so you see what's happening here. We start with the king, take power from the king, give it to the legislature, take power from the legislature, give it to the court. The king, to the legislature, to the courts, and here we are. And now the problem is courts do whatever they want. Okay? So note what's happening. We're not destroying power, we're just shuffling it around. Put it here, put it there, make sure that these people don't do that. Nothing's really changed. It's just a question of who has the power at any particular moment. So, the rule of law. What was the idea supposed to be? Well, legal theorists would say the rule of law is complicated. And there are lots of different opinions about what it consists of. But I think to see the rule of law clearly, compare it to its opposite, which is the rule of persons. You want to get away from the rule of a person like the king. You're trying to create a governance system where you're not subject to the whims of other individuals. Here's 3 bits, and they are not the only 3 bits, but here's 3 bits of the rule of law. The first one, a separation of powers between king or executive branch and legislature and courts. Number 2, the idea that laws apply equally to everybody, including those people who do the governing. And number 3, that we have rules that are, in Hayek's words, fixed and announced beforehand, so we all know what they are. So that they exist before you act, and so someone can't make it up after the fact to catch you. Well, let's talk about the first one first, because it's one of the main themes. In a way, 2 and 3, if you like, are corollaries of a type of the first idea. The first idea is this. Let's say you have something that's very dangerous. Let's say you have a doomsday machine, a dangerous weapon. A weapon powerful enough to destroy both sides in a war. And you can't destroy the weapon. But you can take the weapon apart, maybe into 3. What do you do with the pieces? You put them as far apart from each other as you can so they can't be put back together again. Separation of powers is this idea that we're going to divide the state into these 3 bits. And not just divide them, but say this: the function of each of these bits is separate and distinct. Legislatures, well, legislate, hence the word. They make the rules. The executive branch, or the administration, if you like, they execute the rules. They enforce the rules. They do the little jobs that are necessary to put the rules into effect. But they don't make the rules. And the courts, they take those rules passed by the legislature and they apply them to the particular cases that come before them. And the basic proposition with respect to the idea of separation of powers is that none of these branches shall do the job of the other. And in this way, we are free. Why? Well, because the legislature has to make the rules without knowing the disputes to which the rules will be applied, because they haven't happened yet. They have to work in the abstract without knowing the future. The executive have their hands tied because the rules have been made already, and all they're able to do is carry them out according to their terms. And the courts, they are getting the particular cases But they're not allowed, in theory, this is the theory, they're not allowed or able to decide on their own, on a whim, what the outcome of the cases are because they have rules to apply. Rules made by the legislature. And so in this way, there is nobody in the system, no one in the system who can decide alone what is going to happen in any particular circumstance. They are all relatively powerless by the walling off of their functions, and never the three shall meet. But that's not what happens now. The rule of law does not work. So, I've been talking about the mistake up until now. I'm going to talk about the consequences of the mistake. And again, what was the mistake? I said this, the mistake is we didn't go far enough. And here's what I mean by that. We didn't say to the king and to the legislature and to the courts, no, you do not have authority to rule over us. We don't want to do it that way. We don't want to just shuffle power around. We want to get rid of it. We didn't do that. And the rule of law, although arguably it worked for a good while, for periods, it's not working now. So, what are the consequences of this mistake? Well, here's a story. Almost 1,000 years ago, William the Conqueror vanquished England and created a feudal system of a feudal society. Okay? If you were an elite in a feudal society, unless you were church nobility or a member of the royal family, you were probably a land baron. Land is the foundation of a feudal economy, a feudal society. Land rights and social standing are inherited. Lineage. It's hard for us to imagine today because we don't live in this in that kind of a time. But lineage is not just an organizing principle. It's not just a way to figure things out. Lineage is a moral principle. Good and important people are born to good and important families. If your parents are serfs, you are a serf too. And you deserve to be a serf. That's the idea. God determined who you are and who you're meant to be. In a feudal society, lineage is destiny. Now I'm going to fast forward this story all the way through the Enlightenment and to the Industrial Revolution. Because what happens is this elite falls. And of course, I'm oversimplifying, but work with me. Man, and they were mostly men, began making machines. And machines began to do the work. Industry, not land, becomes the basis of the economy. Now, land's still important, of course, but land becomes a commodity instead of the central piece that defines how the society works. And the land aristocracies, like the patricians of Downton Abbey, start to fade away. What comes to matter is not lineage, but productivity and merit. as measured by success in the markets of industrial capitalism. A new elite emerges. Capitalists, entrepreneurs, innovators, and a bourgeois middle class. We think we still live in this society, but we do not. Because here's what happened. That elite doesn't last very long. Something else happens pretty quickly. I'm going to read you a paragraph from a really great piece by N.S. Lyons called The China Convergence. Here's how he describes it. Sometime around the second half of the 19th century, a revolution in human affairs began to take place, occurring in parallel to and building on the Industrial Revolution. This was a revolution which upended nearly every area of human activity and rapidly reorganized civilization in order to manage the growing complexities of mass and scale. The mass bureaucratic state, the mass standing army, the mass corporation, mass media, mass public education, and so on. This was the managerial revolution. A managerial society was born. A managerial theocracy, if you like. A theocracy is a form of government in which God is notionally the supreme ruler, but God's laws, of course, must be interpreted by ecclesiastic authorities. And so, in effect, those authorities are in charge. They're like God's handlers. You know, no one else gets to speak to the big guy, so only they know what he really means. So, in a managerial theocracy, management is the God. The authorities are technocrats and experts. They determine what management requires in any particular situation. So, if you are an elite today, you're probably not an entrepreneur. Instead, you belong to this managerial class. You plan, you direct, you engineer society. You make policy. You develop programs. You spend public money. You make legal decisions or issue licenses or approvals. You are a manager. Now, I don't mean a middle-level manager like a bank manager with bosses above and clerks below. No, I'm not talking about that kind of manager. I'm talking about managers of society. And management has become our secular religion. People don't even know it's there. It's like the water in which fish swim. Belief in the necessity for management is something that people have grown up with. It's all they've ever known. They believe that civilization has become too complex not to be guided by the hand of an expert bureaucracy. There are very few people you will find on the street who will not think that some kind of bureaucracy is necessary in order for us to make our way through our lives. The people believe it. Courts believe it. Politicians of all stripes, and I mean all stripes, believe this. The experts certainly believe it because they are the priests. And even big business believes it now. Capitalists have accepted their defeat. Big business now helps governments to manage the economy. That's not capitalism. That's, what would you call it? corporatism, perhaps. Managed oligopoly for the conglomerates, banks, telecom companies, and so on. The big guys, of course. If you're a little guy, a small entrepreneur, then, oh yeah, well, capitalism still applies to you. What you get is red tape, tilted, twisted market competition, and survival of the fittest. To speak against management, to speak against the administrative state, is to be a heretic. So, how did this happen? How is it possible? Because we had the rule of law, and here's how management works. Management works by giving to individual offices, individual agencies, individual officers, the power to decide the whole thing. You saw it happen. Public health officials got behind the podium at the microphone on a Tuesday and said, the new rule is this. Here's what was going to happen. That is not the rule of law. But it seemed fine to most people because that's the way we do things now. We manage you. And the people want to be managed. Authority and expertise. Now, I'm going to go back to the separation of powers because something happened to it. If the separation of powers worked, then management would not be possible. Managers hate the rule of law. Hate it. Why? Because it's inconvenient. If one branch makes rules, one branch executes rules, one branch applies rules, that's just terribly inconvenient. That's very inefficient. That won't work. We have to be much more efficient than that. Here's the thing to remember about the rule of law. That feature that gets in the way of experts solving problems, solving social problems, that is not an inconvenience. That's the whole point. That is the purpose of the rule of law, to prevent exactly that from happening, which is why we don't really have the rule of law anymore. And this is how it happened. So you have these three branches. Now the legislature is supposed to make the rules. That's the theoretical proposition. But here's what they do now. They pass statutes, and there are sort of some rules in those statutes, but the more important part of those statutes is this. Those statutes include a section or sections that delegate rule-making powers to the executive branch. Regulations and policies and guidelines and directives and orders and so on. In other words, the legislature is delegating its role to the administration. And for the courts used to have this role. Their role used to be to make sure that the executive branch, the administration, stayed within its statutory mandate, to make sure it didn't do anything more than that was specifically given to them in the statute. But today, because the courts believe in the managerial state, courts now defer. So let's say an agency has wandered outside a little bit its statutory mandate. The general rule, not always, not every single time, this is not a black and white thing, but courts tend to defer to the authority and expertise of the administrative agency. So, delegation from the legislature, deference from the courts, leads to discretion on the part of the administration to act in the public good, which results in what I like to call the unholy trinity of the administrative state. These three bits, delegation, deference, and discretion. And that makes management possible. So instead of the rule of law, Now, I'm going to describe it to you this way. We took power from the king, gave it to the legislature. We took power from the legislature with bills of rights and charter of rights and gave it to the courts. And now the legislature and the courts are giving the power back to the king. Now, it's not the king, it's the executive branch, what is now really in place of the king. So round and round we go, shuffling power from one place to the next. Oh, in fact, I just thought I'd add this in. Sometimes people now speak of a fourth branch. They've separated out the executive branch and the administrative branch. These are not really different things, but there are a number of agencies now within the executive branch of government that are thought to be independent of interference from the political people who run the executive branch. So think of, for example, the Bank of Canada, or Crown prosecutors, law enforcement, maybe public health. People are now apt to say there should be no interference from the politicians, the cabinet ministers, the prime minister's office, in the functions of those outfits. And it's not a bad argument in some context, but just watch what has happened. Now we have independently powerful agencies existing inside government, consisting of people who are not elected and not judges. It's a very strange place to land. In any event, what we end up with is not the rule of law. This is rule by law. This is sometimes called legal instrumentalism. In other words, law is still there. We have lots and lots of laws. This is not, when I say the rule of law is gone, I don't mean laws are gone. We have lots and lots of laws. The rule of law does not mean we have laws. We have laws coming out the yin-yang. But these laws are instrumental laws. This is the state using laws to achieve their purpose. It's not the same thing as the rule of law at all. The rule of law restricts what governments can do. Rule by law occurs when governments are using law as a tool. And the two things are incompatible. You can't have one and the other. And note what happens. If you have rule by law, in which rules are fluid, bureaucracies make rules as they go along, just like public health. Today is Tuesday. Today the rule will be X. If you are making the rules as you go, then the rules don't apply to you. That doesn't make sense. So you're breaching another one of the bits of the rule of law, which is universal application of the same standards to everybody. Instead of blind justice, where the rules do apply equally to everybody, we have the requirements of equity, where different rules apply to different groups of people. That's not corruption. That's just a feature of managerialism. So, if you take this managerial revolution seriously, it can explain almost everything else. It explains wokeism, it explains COVID, it explains the obsession with climate change, it explains the transhumanist inclination, the transgender stuff. Why? Why do all these things happen under a program of managerialism? Well, to put a too fine a point on it, it's because all these things need to be managed. Let's try putting it this way. I mean, and it may be that some people in government actually believe in these things. That's possible as well. That happens, of course. But more importantly, An unending quest for social justice, for example, provides legitimacy to unending state intervention, because you can never get there. Equality of outcome between groups, policing hateful thinking, defeating historical privilege, those all require expertise and special knowledge, and that's what management is about. COVID was a perfect managerial storm. Now you'll note this about all of this management stuff. When I say management, we're not assuming that the management is effective. It doesn't work. Terrible. COVID is a perfect example. It doesn't produce good outcomes, but that's not the point. The point is not the outcome. The point is the control. Okay, so how do you fix this mistake? Power to the people. Power to the people. Power corrupts. So, design a system that does not depend on power. That's very difficult to do. Because remember what I said, law is power. So are we describing a system in which there is no law? That's anarchy. What are the alternatives? Let me start with this. The idea of individual rights is backwards. Your rights in the Charter, in Diefenbaker's Bill of Rights, in the rights in the American Bill of Rights, the idea is backwards. Because it works this way. It says, legislatures can do anything except. It's the exception to the general rule. And that exception has to stand in the way of what the state wants to do. And the court has to agree that that, in fact, does stand in the way of what the legislature wants to do. So you flip it. You say instead, the state can do nothing unless. Now, what is the unless? I'm going to suggest to you this. Unless people give their consent. Citizens are subject to no laws prescribing their conduct except those to which they have consented. Now let's be clear. I do not mean as a group. We're not talking social contract theory. You may have heard of this, social contract theory. The idea that the body politic has consented as a group to being governed in the way that they are. Social contract theory, a complete fiction made to legitimize a system of government. The argument goes like this, I think. If the people are not rioting in the streets, then they have consented to what is happening. I don't know about you, but I was never asked if I consented. I signed no contract. And for the record, I do not consent. I do not consent to huge chunks of the laws that now apply to me. I do not consent. And I obey them. I obey them. Why do we obey them? Why do I obey laws that I do not consent to and do not approve of? Why? There is only one reason. And it is the first legal reason. It is the reason why we say that law is based upon violence. The reason that I comply with laws that I do not consent to and do not agree with is because if I do not, I will get into trouble. And eventually, maybe not the first day, but eventually down the road, the police will come to my door. That's why law is based upon violence. So, if we're not talking about group consent, then we're talking about individual consent. And that's what I mean. I mean, no individual is subject to laws to which they and they alone do not consent. I would put it this way. Every citizen gets the following election. Do you consent to laws that prohibit force and threats of force between persons and between persons in the state? And then you let this play out. Now, there's more to tell. I'm not going to try and tell it now. But this is the beginning of thinking through a different model for our government. The case I would make to you is that the old model, it did work for a while. It appeared to work very well for a while. It does not work now. And there's lots of questions to answer about this one. But I think we start with a different premise. And I think the premise has to be that we are all entitled to not be subject to laws that govern our conduct unless we explicitly consent to having those laws apply.